And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
Your constitutional rights used to depend on your mailing address. That is a terrifying reality that defined federal civil rights litigation across the country for years. If you lived in the Ninth Circuit, covering the West Coast, your protections against excessive police force were substantial. If you lived in the Fifth Circuit, Texas, Louisiana, Mississippi, those protections often vanished entirely. The Supreme Court just ended this geographic disparity. In a sweeping, unified decision, the Supreme Court declared that when courts evaluate the constitutionality of force used by law enforcement, they must examine the totality of the circumstances leading up to the incident. They cannot simply focus on the split second when force was applied. The core decision. The Constitution requires courts to consider an officer's tactical decisions and conduct that created the dangerous situation, not just the danger itself. This 9-0 ruling resolves a massive conflict that had left federal law in chaos for over a decade. To understand why a unanimous ruling on something this divisive is staggering, you need to see the disparity. Before this decision, different federal appeals courts were operating under completely opposing standards. Lawyers felt like they were rolling dice, hoping their client's case landed in a favorable jurisdiction. The federal government itself was forced to argue different legal positions in different circuit courts because the rules literally changed based on the courtroom door you walked through. We are talking about fundamental Fourth Amendment protections, the right against unreasonable searches and seizures, and the standard for judging force was splitting the country right down the middle. In the Fifth Circuit, judges had adopted what was called the moment of threat rule. This doctrine instructed courts to ignore everything that happened before the force was deployed. Tactical errors, opportunities to de-escalate, reckless choices, all were deemed irrelevant. The only thing that mattered was whether, at the precise instant the trigger was pulled, the officer faced a perceived threat. This resulted in absurd legal outcomes. Officers could engage in aggressive behavior that unnecessarily provoked a confrontation, creating a crisis where none existed. Then, when the crisis materialized, they could claim self-defense and have the force upheld as reasonable because the court was legally prohibited from looking backward. This approach essentially rewarded poor police training and terrible tactical decision-making. Legal scholars universally condemned it. If you create the danger through unreasonable actions, should you be allowed to claim necessity when that danger inevitably erupts? The answer, for years in large parts of the U.S., was yes. The case that finally broke this untenable situation involved an individual interaction that escalated rapidly. The initial encounter was routine, but the individual chose to leave the scene, triggering an immediate and disproportionate response from the officer. In less than 30 seconds, a split-second choice by the officer resulted in the use of force that had permanent, life-altering consequences. When the individual's family filed a federal lawsuit claiming excessive force, the lower court, applying the moment of threat rule, refused to look at the crucial decisions made moments before the force was used. That refusal was the central point of contention that carried the case to the Supreme Court. The reason the court accepted the case, out of over 7, 0 petitions annually, was the undeniable circuit split. The Fifth Circuit's rule was in direct documented conflict with the standards used by the 2nd, 3rd, 4th, 6th, 9th, 10th, and 11th circuits. Those other circuits used the totality of circumstances approach. The court could no longer tolerate a nation where basic constitutional rights varied by zip code. If you are finding this breakdown helpful and want to stay updated on how these major legal decisions impact your rights, take a quick moment to hit that like button and subscribe to Law Advisor. Your engagement helps us bring these crucial legal stories to more people. The unanimous decision when it landed was a shockwave. 9-0. In our current highly polarized judicial climate, 9 justices agreeing on a major constitutional question involving law enforcement accountability is rare. This signals that the legal principle at stake was not a matter of liberal versus conservative ideology, but a fundamental agreement on what the Fourth Amendment actually means. Justice Sonia Sotomayor wrote the opinion for the court. Her analysis was rooted in constitutional text and history. She explained that the framers understood reasonableness to be a contextual inquiry. When the Fourth Amendment demands that government action be reasonable, it means courts must look at all relevant circumstances, not just an isolated moment frozen in time. The court held that the Fifth Circuit's moment of threat rule was not only unconstitutional but also illogical regarding police practice. Citing precedents like Tennessee v. Garner and Graham v. Connor, the court reiterated that context matters. You cannot evaluate the reasonableness of a government action while ignoring the unreasonable events that directly led to it. If an officer's tactical choices recklessly create an immediate need for force, those prior choices are relevant to the constitutional analysis. They cannot be excused simply because a threat materialized in the final second. The immediate implications are vast. Hundreds of excessive force cases currently pending in federal courts nationwide must now be reconsidered. In the Fifth Circuit alone, dozens of active lawsuits, where plaintiffs were denied justice based on the rejected moment of threat standard, will now be sent back to the lower courts. These families finally have a legitimate second chance to argue the full facts of their case under the correct, constitutionally mandated totality of circumstances standard. The ripple effects extend directly into law enforcement training. Police departments across the country must immediately update their use of force policies. Training curricula must now emphasize that accountability spans the entire encounter. Officers can be held liable not just for the final act of force, but for the unreasonable tactical decisions and risk assessments they made leading up to that final moment. The Supreme Court has unequivocally stated that sound tactical decision-making and constitutional compliance are two sides of the same coin. Departments that ignore this mandate do so at their own massive legal peril. Perhaps the most powerful message of this ruling was the absence of dissent. There were no concurring opinions arguing for a different rationale. All 9 justices, including the most conservative members of the bench, signed onto the same opinion. This unanimity signals a clear boundary. The Fifth Circuit had adopted a rule so fundamentally incompatible with the Fourth Amendment's text and precedent that it could not be defended by any justice, regardless of their judicial philosophy. The reshaping of constitutional law extends far beyond excessive force claims. The court's reasoning clarifies how reasonableness is analyzed whenever the Fourth Amendment is invoked. This means the totality of circumstances standard applies equally to searches, seizures, traffic stops, arrests, and investigatory detentions. If officers take unreasonable steps that create an emergency, exigent circumstances, those preceding steps are now relevant to the constitutional analysis of the resulting search. Scholars are already examining whether this logic extends to other constitutional provisions that require a measure of propriety or reasonableness, such as the Fifth Amendment's Due Process Clause or the Eighth Amendment's prohibition on cruel and unusual punishment. When the constitutional text requires a contextual evaluation, the logic of this unanimous decision mandates looking at the full picture, reinforcing the idea that text and history are paramount, regardless of the ideological leanings of the justice applying them. What happens next is implementation. While the legal standard is now fixed nationwide, lower courts must still apply judgment to the facts of each individual case. Different judges will reach different conclusions about whether force was reasonable under the totality of circumstances, but they are finally all operating under the same set of constitutional instructions. For every citizen, this ruling matters profoundly. It guarantees that the Fourth Amendment remains a real protection governing interaction with law enforcement, ensuring your rights are evaluated fairly based on everything that occurred, not just a conveniently frozen moment in time. This significant shift prioritizes accountability and incentivizes better tactical decision-making, which could ultimately save lives. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, knowledge is the ultimate defense. I will see you in the next one.